Okay, Mr. Blumberg, are you able to hear me okay? Oh, I think you're muted.
Can you hear me now?
There we go. All right. Mr. Backlund, are you there?
I am here and I can hear everybody, Your Honor. Yep.
All right, great. Thank you. Happy New Year, everybody. We're off to a rollicking start this morning here with the weather. But I'm glad you're both connected. So we'll go on the record in Haskell versus Haskell, file number 2218880. If I could have counsel put your appearances on, though, please.
Certainly, Your Honor. Zach Backlund on behalf of the plaintiff in this matter, Aubrey Haskell, who it looks like is appearing by Zoom as well.
Good morning, Judge Elliott Blumberg on behalf of David Haskell, who's appearing via Zoom from my office.
Okay, this was set today as a status conference. Mr. Backlund, on behalf of the plaintiff, can you tell me where things are at? It looks like there were some proceedings in December.
That's correct, Your Honor. There were proceedings in front of the referee regarding child support arrears. And this case has been going on forever, and one of the ongoing issues that we've had to navigate through are the arrears. So what we examined was simply the arrears for the effective current date of the child support, which was November of 2024 to the present. We solved that by a resolution to waive the child support arrears from November 2024 to the present specifically. I believe that hearing was on December 3rd. There is the issue. I spoke with Mr. Blumberg this morning regarding potential spousal support arrears and credit for those. However, in my discussion with Mr. Blumberg, it could have just been me, but I wasn't sure if we could potentially still enter a judgment on this matter. I know we tried it way back in December, I think, of 23 at this point, to hear the matter of the parties' agreements regarding spouse support, child support, and the division of debts and equities. Knowing that there were potential black holes these parties could fall into regarding some of the language in that agreement, Mr. Blumberg and I have tried to resolve those and, get down to the issues specifically involving repairs to the house. We haven't been able to resolve that between us. So I'm almost wondering, Your Honor, if we could simply enter a judgment holding the matter of the arrears to still be resolved, because I believe everything else would be if we were to simply enter regarding the parties' previous agreements and the old spouse support and child support orders that were part of those original agreements years ago. And I know we do have an effective child support order in place right now.
All right, Mr. Blumberg.
Well, you want me to be muted again? It'd probably be easier if I was. Mr. Backlund and I have been working fairly diligently to try to get these issues resolved, and I know the court is most anxious to get a judgment entered. This is a 2022 case, and we would like to do that if the court would allow us, and I guess in a post-judgment manner, resolve any of the issues that are still unclear. Does the court have a view of whether that can be done or not?
I think we can do that. Okay. And I think it would be appropriate to the extent that we have agreements that if there are issues regarding how those agreements should be carried out, which it sounds like that's where we're at, then I think that should be or could be handled post-judgment. So I don't see any reason why we couldn't take proofs and enter a judgment today.
Okay.
Okay.
And I know, Your Honor, we had taken proofs, or at least the statutory proofs, way back in December of 23. I wonder if those could be held in abeyance or used to enter the judgment simply regarding residency, when they were married, where they were married, how many minor children, and things of that nature. I believe that testimony has been taken, if that could be used.
Mr. Blumberg?
I have no objection to that. No, I think that's proper.
Okay.
All right, so the court will then just take notice of the previous testimony that was entered in this case. Obviously, I haven't reviewed that transcript I'm going to assume that at the time that that testimony was taken, the court found that the statutory grounds for divorce had been met by the testimony of the parties. So I'm going to rely on that previous testimony and grant the divorce. And then is it going to be a matter, Mr. Backlund, of you and Mr. Blumberg just drafting up some judgment language, submitting that, and then do you both want me to set this for some type of evidentiary hearing regarding enforcement, or does one of you want to notice it up after that judgment's entered? How do you guys want to handle that from a procedural standpoint?
To answer the first part of your question, I can provide a proposed judgment to Mr. Blumberg, and hopefully we could enter that by stipulation. I know I've started one in the past. Hopefully that wouldn't require too much tweaking to do that. In terms of a hearing, I suppose perhaps we want the judgment entered before then, but I can defer to Mr. Blumberg in terms of what he would want to do, because I know it's his client who would like to see some credit toward the arrears.
Yeah, I guess my thought would be, Judge, that we could get the judgment entered, and Mr. Backlund and I could continue to work to see if we could resolve the issue of any direct payments that should be properly credited. And in the event that we can't, then either one of us could schedule it before the court for an evidentiary hearing.
Okay, great. So I'm not going to set it for further hearing then. I will leave that to the parties. Once the judgment is presented, the court will sign that. Otherwise, the court isn't going to schedule any further proceedings. Is that acceptable, Mr. Backlund?
Yes, it is, Your Honor. Thank you.
Mr. Blumberg?
Yes, Judge, it is.
Okay. All right. Thank you. That's all I have for today then, and all parties on this file are free to disconnect at this time.
Thank you.
Thank you, Your Honor. Yeah.
Okay, counsel, if you could both unmute, please. And we'll go on the record in Hogue versus Hogue. This is file number 2520231. If I could have both counsel put your appearances on.
Reagan Richards, Legal Services of Northern Michigan, on behalf of plaintiff Karen Hogue, who is seated behind me. Apologies if there's any issues on my end, Your Honor. My internet's down at my office, so I'm doing this from my phone.
Good morning, Your Honor. Brooke Robinson, appearing on behalf of the defendant, Adam Hogue, who is seated next to me in my conference room.
Okay, and just to clear up, Ms. Robinson, I show Ms. Compton as counsel of record. Are you sitting in for her today? Are you?
We did file an appearance. Ms. Compton has left our firm.
Okay, so you're counsel of record then.
I am now.
Okay, sorry, I may not have seen that. Okay, I do see that now. All right, thank you. So we're on the record here today. I believe this is an initial scheduling conference in this case. On behalf of plaintiff, Ms. Richards, can you tell me where things stand at this point and what you would like to request for scheduling going forward to get this resolved?
Yes, Your Honor. I believe the Domestic Relations Verified Financial Information Form has been exchanged, so we're just in the middle of negotiations. So I would just ask that discovery just be open and potentially mediation if defendant is agreeable.
Okay, Ms. Robinson?
Yes, I would agree with that we open discovery, and I would ask that we get a referral to mediation on this one.
Okay, Ms. Richards, 60 days, 90 days for discovery and mediation?
I would say 60 days, Your Honor. I believe that most of the issues have been resolved, that the parties are living apart and have been for some time.
I would agree with that.
Ms. Robinson, I'm sorry. Okay, so the court will order that discovery to remain open for 60 days. Court will set this for, or refer this to community mediation to occur within that 60-day period. I will set this for a status conference at about 60 days. If the parties have been able to reach agreement, then we can use that date to take proofs and enter a judgment. If not, then we can discuss what needs to be addressed to get it resolved from there forward. Ms. Richards, any other dates I can address for you today?
No, Your Honor. Thank you.
Ms. Robinson?
No, Your Honor. Thank you very much.
Okay, I'll put those dates into a scheduling order that will go out to the parties, and then I'll also send out notice of the date and time of that status conference in about 60 days, and all parties are free to disconnect. Thank you.
Thank you.
Thank you, Your Honor.
In a busy courtroom session, the judge handled multiple family and civil cases back to back. One long-running divorce moved toward final judgment, while another was officially finalized after sworn testimony. Elsewhere, unresolved disputes were set for mediation or evidentiary hearings, as the court pushed both sides to either settle or prepare for trial.
Okay, we'll go on the record now in Crisell versus Crisell. This is file number 2419939. If I could have both counsel put your appearances on.
Good morning, Your Honor. Brooke Robinson on behalf of the plaintiff, Kendall Crisell.
Morning again, Judge Elliot Blumberg on behalf of the defendant.
All right, thank you. We're on the record today for a status conference in this case. When we last met back in November, we discussed setting this for a evidentiary hearing with a final status conference. Prior to that, we do have that evidentiary hearing scheduled for January 15th for a half a day. So, Ms. Robinson, has anything occurred between the last hearing and today that has resolved the file, or where do things stand, at least from your standpoint?
We are not resolved, and I believe we will be moving forward with that evidentiary hearing right now.
Okay, Mr. Blumberg?
I agree with that, Judge. Nothing has been resolved. There was also an issue back in November as to whether or not an objection had been timely filed in regard to your ex parte order regarding the placement of the child in the school. We understand that that's the order of the court for at least this school year. So the scheduling order that we received, or at least the notice, sort of outlined the issues to be resolved on the 15th. Am I correct in understanding that the hearing is limited to those issues?
Yes, correct. That was my understanding based on my notes, to the extent that there was going to be a challenge to the ex parte order or custody issues, that I got defendant to file a motion regarding custody and objection regarding the ex parte order on schooling. So you're still welcome to do that at any point, but in terms of the evidentiary hearing, I think that's going to be limited to the assets and debts, property issues.
That's fine. Is there the standard requirement as to exhibits and witness lists, Judge?
Yeah, so that's something that we didn't address back in November. I am going to request that the parties exchange witness and exhibit lists within the next 7 days, and that each of you provide to the court. Again, I don't need anything like incredibly detailed, but a trial brief just breaking down what the property issues are and each of your proposed divisions of the property and debts.
Very good.
Okay, and then we'll plan on going forward on the 15th at 9 a.m. That's going to be an in-person hearing here in the courtroom. Ms. Robinson, anything else I can address for your side?
No, Your Honor. Thank you.
Mr. Blumberg?
No, Judge, thanks.
Okay, thank you. We'll see you everybody on the 15th.
Okay.
Thank you.
All right, are you Ashley Filer? Sorry, I could not hear that. Could you repeat that?
I am.
Okay, there we go. Great. All right, so we'll go on the record in Filer versus Filer. This is file number 2520218. I have this set for a hearing to enter a final judgment of divorce. Ms. Filer, is that how you wanted to proceed today?
Yes.
Okay, I'm going to place you under oath. After I do that, I'm going to ask you some questions. The questions that I'm going to be asking you are those that I'm required to ask in order to establish the grounds for divorce under Michigan law. So if you could raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. And again, your name is Ashley Rose Filer, is that correct?
Correct. Yes.
Okay. And Ms. Filer, you filed a complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And have you and Sarah divided up all assets or debts of the marriage between the two of you?
We have.
Are there any issues regarding the division of assets or debts that remain for the court to decide?
No.
I see that there are two vehicles under the judgment. You would be receiving the 2016 Ram Sport, and Sarah would be receiving the 2023 Mazda. Is that correct?
Yes.
Are there loans attached to those vehicles?
There are.
Okay. Is Sarah on the loan for the Sport, or are you on the loan for the Mazda?
We're on both the loans together.
Both your names? Okay.
Yes.
I just want to make sure that you understand that, even though the court's going to enter a judgment saying that she's responsible for all the payments on the Mazda and she's getting possession of that I can't order the bank to, take your name off that loan. So until she refinances hers and you refinance yours, both of you will still be on those loans. So that could affect your credit if she doesn't make those payments and she doesn't refinance it. Do you understand that?
Yes.
Okay. All right. And then the only other thing that I see here, because this is a default judgment, I know that under paragraph 16, there's an indication that her name is to be changed to Bosman from Filer. Without her here making that request, and because this is a default, I can't order her name to be changed without her being present or requesting that. So I'm going to strike that paragraph. Do you have any questions about that?
No.
Okay. All right. Other than that, the court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. I've reviewed the proposed judgment. I find that it's generally equitable and contains all the provisions required by statute and court rule. So the court will sign that judgment with today's date. I'll also note that, as I indicated, this was a default judgment of divorce. It does appear that Sarah was properly served with the notice of the summons and complaint that she did not answer, that a default was entered back in November. She was provided notice of the default as well as of the date and time of today's hearing, which was 9:30. It's now 9:36. She has not appeared to contest or otherwise object to the entry of the judgment today. So I will enter that judgment. Your divorce is final as of today. Ms. Filer, did you have any questions at all?
No, I don't. Thank you.
All right, thank you. You are free to disconnect at this time.
All right. Thank you so much.
The day ended with a personal injury lawsuit moving into full discovery after a slip and fall incident at a retail store. With timelines set, mediation scheduled, and deadlines in place, the court made it clear cases won't sit idle. In court, progress matters as much as outcomes.
Good morning, Your Honor. Paul Shuby on behalf of the plaintiff, Russell Kohanic.
Great, good morning. And let's see, Mr. Watt, you're appearing on behalf of defendant ABC of Gaylord.
Yes, Your Honor.
Okay. All right, we'll go on the record then in Kohanic versus ABC. This is 25-20254. Record should reflect both counsel are present today by Zoom video. This is set for a pretrial scheduling hearing in this case. Mr. Kohanek, can you just tell me a little bit about your claims here?
Oh, I'm sorry, I'm Mr. Shibley for Mr. Kohanek. I apologize.
I'm sorry. It's Monday after the new year.
And I apologize. I didn't wear a suit because I'm not feeling very well. So I apologize for not wearing a suit this morning, Your Honor. In terms of the claim, Mr. Kohanek went to the ABC warehouse in Gaylord, slipped and fell. He suffered a leg fracture as well as aggravation of some hip arthritis and some spinal injuries. He treated for approximately 6 months. His foot was in a fiberglass, I believe a cast for a while. And we did try to resolve it pre-suit. Unfortunately, that wasn't successful, which led to the filing of the subject lawsuit. I just dictated my disclosures yesterday and just signed them. Those are going over to Mr. Watt's office this morning. I don't think it's a extremely complicated case. Mr. Kohanek, to my knowledge, is no longer treating. He's just kind of dealing with the circumstances. We are sending over the medical lien, which Mr. Kohanek has incurred with his health insurance company through his employer's health insurance. I believe there may be a few months of wage loss, but it's a slip and fall case on ice and snow. And I believe, if I recall correctly, I think we did give an interview to the insurance representative from ABC, but I'm not 100% positive. But we did attempt some pre-suit negotiations with their insurance.
All right, thank you. Mr. Watt, anything novel or I guess, unusual about the defense?
No,
in
Your
this
Honor,
case?
this is basically a slip and fall in ice and snow on my client's premises. So we probably just need, I've not been before you before, so I'm not sure what you do in terms of scheduling, but whatever the court's pleasure is in terms of scheduling, we'll obviously want to get the plaintiff's deposition. They may want to depose our people, and we'll get his medical records. And I don't really see this as a complex case, Your Honor.
And I would just ask, in case Mr. Watts, we're sending out our discovery, I would just ask for 45 days to amend if there's a snow removal company that they're going to point the finger at.
Okay, gotcha. We can do that.
Thank you.
So, yeah, we'll allow 45 days to amend pleadings or add parties. Mr. Watt, are you going to want to request an IME?
I think that would probably be correct, Your Honor. Probably just one, an orthopedic surgeon.
Okay. So I guess this sounds like a fairly typical case. My usual order would be 6 months or less if requested by the parties for discovery, facilitated mediation to occur within that 6 month period. I usually go ahead, Mr. Shibley.
I'm so sorry. 6 months is plenty of time. I think, Your Honor, that would be very helpful. And then, Mr. Watt, in terms of Northern Michigan cases, I really like Attorney Matt Coffey. He's not quite up north, but he's in Freeland, Michigan.
Yep, no, I know Matt. That's fine.
Can we use Matt for facilitation?
It's fine with me, sir.
Okay, so we'll notify, Your Honor, Attorney Matt Coffey that we've picked him as our facilitator. We'll seek to facilitate. I think that July would probably be appropriate if discovery's closing 6 months from now.
Okay. I'll note for the pretrial order that the parties are agreeing to Matt Coffey as mediator. All right, and then I think what I'll do then is I'll set this for a status conference. If you guys are looking at July as a mediation, then maybe I'll set this for another status conference in August following that mediation. If the parties are able to reach an agreement prior to that, notify the court, and we'll take that status conference down once the dismissal and final paperwork is submitted. If not, we'll meet at that time again by Zoom like we're doing today. Either side's free to file dispositive motions at any time, of course, but at that status conference, I'll set a cutoff date for any dispositive motions. And then if it looks like we're headed towards trial at that status conference, then we can set dates for trial and everything that we'll need leading up to that. If the parties want to contemplate further ADR, we can look at that as well at that time. But that'll give us a period here to get things moving. Mr. Shibley, any other dates that I can address for your side today?
Do you set a deadline for naming of witnesses, Your Honor?
Not at this point.
Okay.
That's something that we'll address if it looks like we're moving towards trial at that next status conference.
Yes, Your Honor. Thank you very much, and I apologize for not appearing in a suit.
That's okay. I'm recovering from the flu myself, so I get it. Mr. Watt, anything else I can address for your side today?
No, Your Honor, we're satisfied. Thank you.
Thank you for your time. Your Honor.
I'll send out an order that reflects all the dates we've discussed today, and then you'll also get a notice for that next status conference in August, and you're both free to disconnect. Thank you.
Thank you.
Thank you.